Can I start by acknowledging the land upon which we meet this evening and acknowledge the Wurundjeri people and of the Kulin Nations and acknowledge ancestors past, present and emerging. For those of you I haven't met, I'm Jim Waterston, the now not so new Dean. After 6 months, I think that's enough to sort of consider myself in the role and functioning. But in saying that, I would like to acknowledge my predecessor, a man of long standing in the role, someone who's set the standards very high. So welcome along to Phil Rickards and welcome along to everyone else. It's great to have you all here and such a big audience, and no wonder why with the calibre of our speaker tonight. Can I acknowledge Liz and the marketing team for taking my suggestion of not allowing me to stand behind that computer screen. So they've built a wonderful stage and got a lectern. So that's the one innovation I might have added to the Dean's lecture in the time that I've been here. So if that's the best I can do, it's not bad. So I do have the honour tonight to introduce Emeritus Professor Gillian Triggs, and one of the great things about the Dean's lectures is I usually get to spend half an hour or so with the presenter before the session, and so I'd almost forgotten about the drinks and was trying to sort of monopolise Gillian's time and getting the pre-lecture, if you like, so it was enthralling, and I know what we're in for tonight. Can I also thank you, Gillian, for making yourself available? She just flew in from Manila at lunchtime today, so change of temperature, change of scenery, but also that long-haul flight. So we're really appreciative of you making yourself available to us tonight. I guess, as I said, one of the great privileges of being the Dean field is to be involved in these situations. And I had come along to one or two Dean's lectures prior to being appointed in this job and found them to be enthralling occasions. But I think tonight we've got a lecture presented by someone who's a well-known Australian who has, in my view, displayed enormous courage, compassion and integrity in the face of hostile media and the politics of playing the person and not the issue. And I think from that point of view, Gillian has proven herself to be a great Australian that's prepared to stand up for those who aren't able to stand up for themselves. So in terms of the formal introduction, let me tell you that Professor Triggs has had a remarkable career combining her academic knowledge with an international commercial legal practice. She has advised the Australian and other governments and international organisations on legal and trade disputes, including advice on the practice of human rights law. She graduated in law from the University of Melbourne in 1968 and gained her PhD in 1982. From 2007 to 12, she became the Dean of the Faculty of Law and the Challis Professor of International Law at the University of Sydney after she had served as the Director of the British Institute at the British Institute of International and Comparative Law from 2005 to 7. I didn't realise that you'd been a Dean when we spoke this afternoon. I could have got some tips off you. So, she is a former barrister and a Governor of the College of Law. Most recently, Professor Triggs served as the President of the Australian Human Rights Commission from 2012 up until last year. I'm sure none of you need to be reminded about that and about the wonderful job she did. After her tenure with the Human Rights Commission, Professor Triggs has joined the Justice Connect as chair to pursue her commitment to ensuring that all people have a fair chance to access justice, including people experiencing homelessness, elder abuse, family violence and financial exploitation. Gillian is also a Vice-Chancellor's Fellow at the University of Melbourne and Vice President of the Asian Development Bank Tribunal. In addition to her role as chair, Professor Triggs is focusing on helping lawyers get out of the office and meet people who need legal help where they live. One page to go, if I can just get it out. She is the author of many books and papers, and her most recent book, Speaking Up, will be published by the Melbourne University Publishing in October of this year. I'm sure we're all eager to, and my voice is just about gone, so I'm sure we're all eager to hear Gillian, and without any further ado, I'd like to welcome you to the stage tonight. Thank you, Gillian.
Thank you very much, Jim. Very kind of you, and I very much enjoyed our half an hour before we came. I think you're going to be an excellent dean. I love this transparent rostrum. I've spent so much of my teaching career behind one of these monstrosities, and you're all educators, you know just how you cannot communicate behind one of these things. However, standing here, I realise you can see rather more of me than I'd actually intended you to see. It's a huge pleasure to be here with so many colleagues, and of course, in particular field that we work together in various ways when I was at Melbourne. And so it's a great pleasure to be with you. And I too, of course, acknowledge the traditional custodians of the land, the Wiradjuri people. I was particularly pleased to be invited to speak to you tonight because after my 5 years as President of the Human Rights Commission, and certainly since then, I've really come to the view that one of the most important things underlining my concerns about achieving human rights protection in Australia is the lack of education about the law and about our constitution. And I'm reminded of some research that was done by the Electoral Commission a few years ago, a research survey on about 3,000 people, and asked the question, do we have a constitution? And 48% of Australians said no. They then were asked, do we have a Bill of Rights? And about 72% of people said yes. And with apologies to any Queenslanders here, not long after I saw a news item in the Queensland press where a man was being arrested for killing his partner, an all too frequent occurrence, and as the cufflinks circled his wrists, he said to the police, "I want to take the Fifth Amendment." Well, we just don't know enough about the legal principles that underpin our democracy, or even understand what we need for an effective democracy. And that is why we came to the view at the Australian Human Rights Commission that it's the educationalists that we most need to work with, because we need to get the kinds of things I'm going to be talking about tonight into the curriculum. And we need our young people to be like any 10 or 12-year-old in the United States will tell you exactly what the opening lines of the United States Constitution are, and they'll tell you about the First Amendment, and they'll know the Fifth Amendment applies in that country. Our young people wouldn't have the slightest idea whether it applied in this one. So what I would like to talk to you tonight is about this extraordinary phenomenon that Australia is the only democracy and the only common law country in the world that does not have some form of charter or Bill of Rights. Now, some might say, well, what difference does that make? We have an almost unique brand of representative parliamentary democracy in this country. Do we really need it? What difference would a charter make to protect our fundamental rights? And what are the arguments for and against a charter? And perhaps I should begin by acknowledging what some in this audience will well remember, and that is that Australia has been historically a good international citizen. Somebody I admired enormously as a law student here at this law school was H.V. Evatt. And you might recall that he was a feisty, brilliant lawyer, very determined to get what he wanted. He was very instrumental in drafting the United Nations Charter of Human Rights and was invited back by Eleanor Roosevelt to draft the Universal Declaration of Human Rights, which he did in 1948. But perhaps something that's not so widely remembered is that in that year, Australia, and represented by Doc Evatt, we were President of the General Assembly. And in that role, he, by sheer force of personality, managed to get the Universal Declaration of Human Rights through the General Assembly without a single negative vote. That was an extraordinary achievement, and it set the framework for all of those treaties that we have subsequently become party to. Australia has been an extraordinary international citizen in leading and ratifying, signing all of the major human rights treaties, from the Universal Declaration to the Refugee Convention in 1951, Convention on the Rights of the Child, Genocide Convention, the International Covenant on Civil and Political Rights, the Covenant on Economic, Social and Cultural Rights, all the way up to the work in 1996 with the creation of the International Criminal Court, where we had our own Sir Ninian Stephen as the ambassador for ensuring that we became a party to that treaty, as indeed we did. So what I'm really suggesting, very, very, as an initial and true point, is that right up until the 2001, Australia really was committed to the body of international human rights law. And we were engaged in negotiating the treaties. We played a very strong role. Like all good lawyers, you produce the first draft. There's some chance you'll have some influence on what it's going to look like. We did that. We sent across some of Australia's best lawyers, draftsmen and politicians to make sure that all of those treaties reflected the concerns that Australia had. But then we come to the year 2001. Now, the historians in the audience might be worried about setting any line in the sand, but I think you can say 2001 was a pivotal year. It was the year of the misstatement by our Prime Minister, Mr. Howard, that asylum seekers, predominantly Muslims, were throwing their children overboard in order to ensure that they were picked up by the Coast Guards and brought within Australian jurisdiction. The Senate, a few months later, found there was not a scintilla of evidence to support that allegation, but it was critically important for that election that Mr. Howard won. A few months later, we saw the Tampa crisis when that Norwegian ship's captain sailed the Tampa into Melbourne waters and into the arms of the federal court judge, who determined that, of course, Australia is bound by the principles of the Refugee Convention and to accord the human rights to those within its protection, including those that on the Tampa. But then we find that a few weeks later, we had the 9/11 terrorist attacks on the Twin Towers and the Pentagon. And what happened, I think, in that year was that we saw Australia turn from a good international citizen to a country which has eschewed the fundamental international principles of human rights law and has ensured by legislation that those treaties do not have practical effect in Australian law. My concern then is that over the years and incrementally, piece by piece, legislation has been passed by compliant federal parliaments and oppositions over the last nearly 20 years, facilitating a creeping expansion of executive powers and non-compellable and reviewable discretions of federal government, unprecedented outside wartime. There are many, many examples. I've mentioned asylum seekers in particular. We hold them now for years, mandatorily, without charge or trial. We now have and continue to have 140 or so children still on Nauru, about 1,300 people in mandatory detention in Australia, and rising numbers on Christmas Island, being ones typically whose citizenship has been stripped from them by the minister on character grounds, many of them New Zealanders. We use metadata retention laws to diminish privacy and freedom of speech, and we pass mandatory sentencing laws that diminish the independence of the courts. Well, for each law, if you consider them alone, we might say that it's reasonable and proportionate, or it's de minimis, it's not worth making a fuss about. Do I, as President of the Human Rights Commission, complain that the law now allows the police to establish control orders in respect to 14-year-olds? Is it going to happen? Maybe once or twice or three times. There'll be an army of lawyers there to protect them. Is it worth using your political capital on these kinds of cases? These things are all matters of judgment. But my concern is that as we look back over these past 2 decades, and certainly in my very direct experience in the last 5 years, we see a pattern emerging where the whole has become larger than the sum of its parts. And we have now, I believe, threats that lie at the heart of our democracy, most particularly the extraordinary expansion of executive power. There are many examples, and one that you'll be aware of very recently is that Australian prosecutors have now charged a former intelligence officer and his lawyer, a former Attorney General in the ACT, for breaching security laws under the Section 39 of the Intelligence Services Act, for revealing to ABC journalists and perhaps others that Canberra had bugged East Timor's Cabinet Office during talks on the oil and gas treaty negotiations worth up to then $40 billion. This raises profound concerns about our treatment of whistleblowers. You might recall, of course, that the matter went to arbitration, to the International Court of Justice. It's been resolved. We now have a treaty with East Timor that perhaps is one that meets the ethical as well as legal concerns. But the point I want to make is that the individuals who blew the whistle on this admittedly illegal spying are now themselves, 5 years later, subject to prosecutions with 2-year sentences if they are convicted. We also, of course, consider this case that has been widely reported in the media in the context in which we have just passed, with almost no discussion at all, the foreign interference law and the new espionage laws. One of the points that I would like to make is that I'm not suggesting that we do not have foreign interference laws or espionage laws or counterterrorism laws or even metadata laws in certain circumstances. We have to defend our country, we must defend our borders. But the problem is that from 2001, and that's why I began with that example, we've seen issues that should be dealt with more proportionately based on evidence merge into a simple statement that these are about national security. And that has given the government an extraordinary power. And when these recent laws on foreign interference and espionage were being questioned by a journalist, the Prime Minister said 2 words, dangerous times, and left the debate. In other words, that is all you need to do to generate sufficient political impetus to pass laws which are unprecedented in Australia and which give the government powers that they have not had outside wartime. There's another example. I wasn't in Melbourne at the time, I wish I had been, but you'll all remember Operation Fortitude. It was a rather encouraging example because you'll remember that the Border Force officials declared that from that day they were going to stop people and question them to make sure that they had a proper visa, that they were in Australia validly. Now, of course, Australians, in Victoria at least, responded very quickly to this, that we were going to have officers all over Melbourne stopping you, presumably in the Bourke Street Mall, asking you if you had visas or proper papers or were in Australia legally. It was very encouraging that social media learned of this immediately, of the media release from the Border Security. It went out to a wide number of people, and 2 hours later we have a meeting on the Flinders Street station protesting against this law, and the head of Border Force declared that they were no longer going to go ahead with that provision. Now, I think we all know they weren't going to stop me with my David Jones bag. And if they had, I wouldn't have my passport, and I certainly wouldn't have a visa. I am a dual citizen, so I'm very vulnerable. They weren't going to stop me, but they would stop some people that fit what almost certainly is going to be racial profiling. We have never had that in Australia, and we have never demanded that people carry their ID cards with them to demonstrate in a shopping mall that they're there in the country validly. We need to talk about whether we do something of that kind. But subsequent to that event, there was an inquiry by the National Audit Office finding that the powers that the Border Force Act was giving to itself, of course passed by Parliament, would have authorised 15,000 Immigration and Border Force employees to conduct what were considered to be a potentially unlawful search. Now, was Operation Fortitude a triumph for democracy and people power through social media? Was it a sinister Big Brother conspiracy for social control, or just an example of foolishness and incompetence? But it's worth mentioning, at least, that since that event, we now have a new Super Ministry of Home Affairs established in December last year that has never been subject to parliamentary debate or legislation to allow it to occur. We also have extensive executive detention, administrative detention, of those whose visas have been cancelled, being held in mounting numbers on Christmas Island and Villawood. And perhaps I can ask this audience, does anybody in the audience know where Yonga Hill is? Has anybody ever heard of Yonga Hill? Well, you might be interested to know that there are about 350 men detained indefinitely about 2.5 hours drive outside Perth in one of the most sophisticated maximum security prisons Australia has ever built at the cost of hundreds of millions, at least 200 million. And these men are completely without public information, or rather the public is completely ill-informed or uninformed about the existence of this detention centre or of these people who are being held there, most of them asylum seekers and refugees, some of them people whose visas have been cancelled at the discretion of the minister, discretion which is neither compellable nor reviewable by our Australian courts for various reasons. Well, these are just some examples, and I'll come back to others, but what I thought I would explain to you is how it has been that Australia has become so unique in the common law world, certainly among democratic countries, in not having a charter or benchmark against which these kinds of breaches of fundamental freedoms can be measured. And let us start, by way of example, at looking at a decision of the Papua New Guinea Supreme Court, Anamaru against Pato, in April 2016. And some of you might recall this one. It's one in which the men, and they've all been men on Manus Island, challenged their continued indefinite detention on that island, challenged in the Papua New Guinea government. But under Papua New Guinea law, it has a constitution, and in that constitution is a provision: no person shall be deprived of his personal liberty. No person shall be deprived of their personal liberty. It reflected not a left-wing UN General Assembly, it reflected the Magna Carta that's over 800 years old. In 1215, on those swampy grasses of Runnymede, King John was forced to, he couldn't read or write, forced to put his seal the Magna Carta, and in the middle of it, with how many pigs you could have and what your fealty was to your lord, is there a remarkable provision: no man may be detained indefinitely. No man may be detained arbitrarily without charge or trial by his peers. This is fundamental to every system of law that we know of. Now, the Supreme Court of Papua New Guinea had, of course, a modern constitution. It was, had a modern constitution. And that is, in 1975, some of you might remember those rather heady days when Papua New Guinea got its independence. It got a new and contemporary constitution that reflected some of the fundamental principles of the common law of freedom that emerged from ultimately the English system of law. And the Supreme Court said there may be no deprivation of a person's liberty outside what is provided for by the law or the Constitution. And in the present case, the undisputed facts clearly reveal that the asylum seekers had no intention of entering or remaining in Papua New Guinea. It was the joint efforts of the Australian and Papua New Guinea governments that has seen the asylum seekers brought into this country and held against their will without charge or trial. These arrangements, said the unanimous Papua New Guinea Supreme Court, are unconstitutional and outside the legal framework of that country. And on that basis, the detention centre was closed. Now, you will all know the saga. They were ultimately moved to another partly constructed facility on Manus, and except for those 150 or so that have now been accepted by America, they remain on Manus Island, in some cases 5, coming up for 6 years. But let's contrast that decision. So we have a Supreme Court decision that looked at its constitution and said this is a breach of liberty and an ancient principle underlying our law in Papua New Guinea. Compare that with Australia in a decision that was just 3 months earlier, and it was, not very interestingly, called the M68 case. And this was a decision, and there are over time now thousands of these cases. She was a Bangladeshi woman, an asylum seeker. She'd used a people smuggler, had no visa to enter Australia, and she was intercepted on the high seas, detained on Christmas Island as an unlawful non-citizen under the Migration Act. She was transferred to Nauru, she was pregnant, and she gave birth to a daughter in Brisbane a little while later. She was mercifully allowed to come from Nauru into to Brisbane to give birth, given her particular circumstances. Having given birth, a healthy child, she was then to be returned to Nauru, and she challenged that return to Nauru through pro bono lawyers, ultimately to the High Court of Australia. looking for an injunction to prevent her deportation. And the question was whether or not the Migration Act would permit her deportation back to Nauru. And the government officials and the lawyers looked at the Migration Act, and it dawned on them that there was no provision in the Migration Act that allowed her deportation. To do so would be illegal. So what does the government do? It introduces Section 198AHA2 of the Migration Act, supported by the opposition, and applying retrospectively to authorise the removal of this woman and anybody falling into that category precisely for the period at which she first entered the country. In other words, it was a deliberate and, in my view, cynical use of the power to amend a piece of legislation. That passed Parliament, and by the time, 2 or 3 weeks later, it got to the High Court, the majority of the High Court, 6 of the 7 judges, said, well, initially, when we looked at the Migration Act, the government did not have the power to deport her to Nauru. But when they passed, with this obviously through Parliament, a retrospective provision which authorised the Act, it made it valid to send her back to Nauru. Now, there was one dissenting judge, Justice Gordon from Victoria, and she was very, very clear in her short and clear judgment. She said there is a fundamental principle of the common law and of the Australian Constitution. The government has certain administrative powers, but judicial powers may be exercised only by the courts. It is the doctrine of judicial separation. Independent courts are entitled only, exclusively, to impose penal sanctions. And she said, in her view, to send someone back to Nauru in these circumstances was a penal sanction that only the courts could impose, not the government. And on this basis, she found the provision invalid. The majority of the court, however, said, so long as Parliament passed the retrospective piece of legislation, then that was good enough to repair the gap or the damage in the legislation itself, and therefore her return to Nauru was a valid one under the Constitution. Now, I'm very troubled by the point of distinction between these two cases. I don't want to spend too long on the intricacies of that part of Australian law, but I wanted to make the point that time and time again, the lawyers have brought cases to the High Court, and time again they've failed because we have no provisions in our Constitution that will protect fundamental freedoms. But our Constitution was obviously 1901, the newer Constitution in 1975 for Papua New Guinea has those kinds of fundamental freedoms that provide a benchmark for the courts to be able to say, you may not act in this way. And I think that is what is so worrying to me. So how is it then that Australia came to this extraordinary position? Why are we literally unique among democracies and common law countries in not having some either constitutionally entrenched or legislative form? Well, very, very quickly, the Constitution is not really an inspiring document. If you read the American Constitution, it's really rather dreary. You mightn't get to page 3 before you've really completely lost interest. It's essentially a practical document that ensures that we have proper distribution of powers between the Commonwealth and the states, and to preserve those powers as they were understood to be important at the turn of the century. But you might be interested to know that most of the freedoms, the common law freedoms, and the freedoms defined in the human rights treaties I've briefly referred to, are not in our Constitution. We have no right to freedom of speech in our Constitution, a very limited right to vote, even that seen as in equivocal terms by the High Court of Australia. We have no rights against slavery or the rights to protect associations or privacy. One of the very few rights we have in the Constitution is the right to freedom of religion, the freedom of religious expression. Now, if you'd listened to the debate about same-sex marriage, and I'm sure you all did follow that debate, you will know that for the first time in many, many years, we had a debate about whether we needed stronger protections for our freedom of religious freedom in Australia. What that set off was the hair running to say, that we now need constitutional provisions, or at least legislation, that will protect freedom of religion. But in that debate, we had almost no discussion of the reality that it is one of the most strongly protected rights under our Constitution, as distinct from the others. The High Court has implied a right of political communication. It's not quite the same thing as right to freedom of expression. Most critically, the treaties that I described earlier have, for the most part, never been implemented as part of Australian domestic law. So I know that this is only perhaps lawyers would really see this as important, but it is critically important that you go overseas as our diplomats and they negotiate and sign and ratify ultimately treaties. Those treaties make Australia legally viable or liable for breaches of those treaties in the international environment. But unless they are passed by Parliament in the domestic sphere, they do not have any domestic application. And the reality is that while we've been such a good international citizen, most of those human rights treaties have never been made part of Australian law. So that the Convention on the Rights of the Child, for example, is not part directly of Australian law. The International Covenant on Civil and Political Rights, or Economic and Social Rights, is not part of Australian law. The Refugee Convention was in part included in the Migration Act, but this government has stripped those provisions of the Refugee Act from the Migration Act, so that the definition of a refugee is now one ultimately for the minister, but not one which reflects the international treaties. So we have an emerging gulf that the treaty body and the treaty bodies that deal with all of these human rights issues will make proclamations and recommendations and findings that Australia is in breach of international law. Particularly of concern has been the highest rate of incarceration of indigenous peoples in Australia, a really scandalous reality, along with, of course, asylum seeker policy, and another one being the rising numbers of those killed in domestic violence, men, but as you know, predominantly women. So the UN can consider these matters and make reports. The rapporteurs can give reports. The Human Rights Committee can make determinations, and the High Commissioner for Human Rights and the Commissioner for Refugees can all make the point that Australia's policies in various respects breach those treaties, but they have no impact in the domestic environment. So that if I, or through my lawyers, were to go to the Federal Court or the High Court and talk about the Bangladeshi case I mentioned and say this is contrary to the Refugee Convention or contrary to the International Covenant on Civil and Political Rights, I would be met immediately with the answer, that is not part of Australian law. So that we have this bifocal approach to our international legal obligations. So the Constitution does very little in this area. The treaties have not been implemented into our domestic law. We have no legislated Charter of Rights, but we do have common law principles. What about the common law? That's part of Australian law. Why do the courts not, in the case that I've mentioned, why did the courts not say, but there's a common law principle that you can't treat people in this way without at least judicial supervision, the courts to determine whether an offence has been committed and what the consequence would be. And in a criminal context, penal context, you typically have a right to a jury. None of that is happening. So what happens? Why is the common law not really working? Well, you will find over and over again that the Federal Court, but particularly the High Court, will repeat the rules of statutory interpretation, that Parliament is presumed to act in compliance with its international obligations and in compliance with the principle of legality, which essentially means principles against arbitrary detention, the right to freedom of speech, the right to fair trial, procedures and so on, that these are implied. Every judge will say that, and you can read numerous judgments that will repeat that point. But you'll read through the judgment and you get to that crucial paragraph. Parliament has passed a law which is clear and unambiguous. Parliament is the sovereign body, and Parliament has overridden those common law principles. And that is why, in the one case I gave you as an example, but there are many, many others, that is why it has proved to be so difficult, because Parliament is now precisely drafting laws which explicitly breach international human rights law and indeed the common law principles. And that is what has been so difficult. What do we do as lawyers when we have not only the government in power, but the opposition fairly complicit in passing these provisions, usually under the threat of national security, whether it's asylum seekers or terrorism or threats of one kind or another. But let me give you, if I may, very briefly another example of Al-Kateb, probably the most disgraceful decision ever by the Australian High Court in 2004. And this was a man who was born in Palestine-occupied territory and, of course, was stateless, had no nationality at all. He came to Australia without a visa. He was picked up and he was, under the law, taken subject to mandatory detention, introduced in 1992, and he was held in immigration detention in Villawood for about 4.5 years. He said he'd go back. It was a mistake. He would allow himself to be deported. He wanted to go back to Palestinian territory, but Palestine, of course, doesn't exist as a state. Israel refused to cooperate. Jordan also refused to do anything. Egypt or any other country within that region refused to have him into their country because he was stateless. He had no papers, nothing, and not entitled to anything because he was born in a country of statelessness, or where he would always be stateless. Ultimately, he was detained indefinitely. Well, of course, ultimately, he was able to challenge that before the High Court of Australia. And the High Court of Australia, in a majority judgment, took the view that if the legislation was clear in requiring that he be detained indefinitely, if he couldn't be sent to another country, then he would be detained indefinitely. And the end result was that the majority of the court said mandatory detention was so clear that there could be no implication of common law principles against arbitrary detention and the right to trial. Well, I suppose the good bit of the story is that, and this happened quite frequently, I should admit or say, that these cases would go to the court and you would get a very negative view because the court felt it was unable to do anything about it. But the individual themselves might be released a few weeks or months later. And in Al-Kateb's case, he was released, and he now has a humanitarian visa and is a productive tax-paying member of the Australian community. And we found with our work with the detention centres, we raised, for example, the problem of an entire family from northern Iraq that was deaf, and they'd never learned the Iraqi version of Auslan, and they simply couldn't communicate other than by a sort of private language they have with themselves. They admitted they weren't refugees. They said they'd come to Australia because they wanted medical treatment for their children. There was the grandfather, the parents, and the children, all of them completely deaf. Now, that did tug at the heartstrings of the then minister, and they were quickly brought out into the community in Darwin and given access to proper medical care, and I believe are now settling well into Australia. So there were some good stories, but they were tiny relative to the others. Well, what about a charter? What's a charter going to do? How is it going to change anything? Well, firstly, let me say I'm not proposing a constitutionally entrenched Bill of Rights on the United States model. You might all recall the Obergefell case in the US Supreme Court that determined for the whole of the United States that marriage equality was required under the 14th Amendment, which is equality before the law. So that's how the Americans got to that result, because they have a constitutional requirement of equality before the law and interpreted it accordingly. We couldn't do that, and I won't go through the process that you know we've been through. But in Australia, I think we will probably never, at least in my lifetime, achieve a constitutionally entrenched Bill of Rights. We can't get recognition of our indigenous peoples in the Constitution. We can't get rid of the race power in the Constitution. The chance of a fully integrated constitutional Bill of Rights is very slight indeed. But we have made efforts in the past to achieve this. And you might recall that Father Frank Brennan in 2008 did a tour of Australia, in-depth consultations over nearly a year, and he recommended to the then Labor government that there was overwhelming support in the Australian community for some form of legislated Bill of Rights. Now, many will be critical of that. They say, well, if you legislate it in 1 year, you can amend it and change it the next. You can. But I'd suggest that if we started off that way, just as Victoria did with its own Charter of Rights and Responsibilities, we get used to it. We'd learn trust, we'd learn how the courts would interpret the provisions, we would build a jurisprudence, and we'd build a public discussion about the way in which rights actually work. So that was his proposal. And the Labour Party, I think, initially accepted it, and it was part of the Labour Party mandate to introduce a Bill of Rights along the lines of what's called the dialogue model. New Zealand's had the dialogue model, a Bill of Rights, since 1990. The United Kingdom Human Rights Act of 1998 is similar. We also, of course, have a Human Rights Act in the ACT, and I've mentioned the Victorian Charter. The idea of a dialogue model is that a matter comes before the court as allegedly in breach of a provision of the Charter, and the court can then review the action and declare if it is or incompatible with the Charter and send the matter back to Parliament to repair the offending provision. Now, the reason for that so-called dialogue model is that it leaves sovereignty where I think in a representative democracy would all see it should lie, with Parliament. But it means that Parliament is on notice that the courts consider it to be in breach of a human right. Now, that's not to say that a Parliament could say we don't care. It can stay there. But in practice, that's not what happens. And in practice also, no country that's ever enacted a Human Rights Act has ever withdrawn it. Now, linked to the Brexit debate, of course, has been allegations initially by the Prime Minister Cameron that he would use the opportunity to withdraw the Human Rights Act and perhaps negotiate another one. Now, that hasn't happened, and it probably won't happen. And it has never happened anywhere in the world, even though there's sometimes justified criticism of the ways in which these kinds of acts work. So what I'm suggesting is a legislated Charter of Rights very much along the lines of the Victorian Charter. Now, you might say, well, that will really set the cat amongst the pigeons. We'll become litigious like the United States, and we'll have activist judges who will go off on tangents of their own on political ideologies, and we'll be in a terrible mess like the United States Supreme Court. Well, I don't think that court's in a terrible mess, but it's a matter of opinion. But what I'm saying is that is highly, highly unlikely. In this state, in Victoria, only 1.6% of cases before the Victorian courts has ever needed to discuss the Charter of Human Rights here. In other words, it doesn't come up very often. But you might recall there's one case where it did come up and was very, very fruitful. And that was the case of holding juveniles in the Barwon maximum security prison. And you all remember that dispute. Now, what happened was the matter was challenged. It was taken to the Supreme Court of Victoria, and that court found that to hold juveniles in adult facilities was in breach of the provision in the Victorian Charter that protects the rights of the child, which of course reflects the provision of the Convention on the Rights of the Child and the interests of the child being a primary consideration as a matter of law. Now, I mention that because at the Human Rights Commission we tried to achieve the same result in Western Australia. But in Western Australia, there's no such benchmark provision, and you couldn't go to the court and ask the court to make that kind of comment. So that's how it could work. But could I also say that I think in the United Kingdom, the Human Rights Act has been referred to in only about 8% of cases, and a tiny percentage again in New Zealand. Only once, I understand, in 21 years has the New Zealand Supreme Court ever declared a New Zealand law to be incompatible with its own Human Rights Act. What I'm saying is that the importance of the Charter doesn't lie with the case litigation. It lies with informing the decisions of government officials, public servants, and people making decisions, administrative decisions. Once you know, as here in Victoria, in New Zealand, in Canada, United States, most of Europe, parts of Asia, once you know that any decision you make is going to be or subject to review by a court on the basis of whether it's compatible with the relevant charter, that has a huge impact on the decision maker. And that's where the impact of human rights is most felt. There are some who argue that will open the floodgates to litigation, and that we should do what we should remain with what the Labour Party decided to do. It didn't accept Father Frank Brennan's decision to hold a recommendation to create a charter. It decided to set up what's called the Scrutiny Committee, the Human Rights Scrutiny Committee in Parliament. And that seemed at the time to be quite a rational thing to do. In other words, let's be open-minded. If we're not that interested in charters and active judiciaries and litigious approaches to human rights, let's put the protection of human rights where historically it has lain since the 13th century in England, with Parliament. Parliament stands against the King, stands against executive power, and insisted on these principles, supported, of course, by the courts. So when the government, at that time the Labour government, introduced the Parliamentary Scrutiny Committee, I thought, well, let's see if it can work. It's appropriate for Parliament to look at whether or not legislation complies with fundamental obligations of Australia under these international treaties. And I rather foolishly then wrote an academic journal piece. I'm a great fan of Le Carré's spy novels, and I wrote a journal piece called Australia Coming In From the Cold. Well, it was very misnamed because it became very clear that it was nothing more than a rubber stamp for the government of the day. And Mr. Ruddock is now the chair of that committee, and the committee almost always breaks down along pure ideological and party lines. So sadly, that scrutiny committee has not been a scrutiny committee, and when it has chosen to report, it's usually reported in the most broad terms with very little legal jurisprudence behind it, and typically those reports will never be referred to in the floor of Parliament when debating a particular bill. So it hasn't been successful, and I say that with disappointment because I think we could say in Australia, we haven't gone down the path of legislation for human rights. Let us try another way. Let's work with our parliamentary bodies. We get Parliament. We get the idea of representative democracy. Let's work with our parliamentary representatives to protect these rights. But my concern is that that's not what they've done. They have not lived up to that expectation, and they've split along endlessly ideological lines. But there are also others, including in particular the Solicitor General in New South Wales and of course the former Premier of New South Wales, Bob Carr, that political issues are for Parliament and judicial issues are for the courts. Never the twain shall meet. In other words, human rights are in the political sphere, they're not for judges. Well, that is simplistic, but an entirely false argument. Politics, Parliament and the courts interact and overlap constantly. Legal and political questions are invariably intertwined, and human rights and fundamental freedoms are deeply and clearly integrated in a way that they cannot be separated. And indeed, I think we have to understand that sometimes the greatest reforms of our law have come not from the leadership of Parliament, but from the leadership of the courts. One example, of course, is the High Court's decision in the Mabo decision number 2, which overturned the idea of terra nullius, fundamental change in jurisprudence adopted by that court. But others, the lawyers in the room will know about the Tasmanian Dams case, expanding the external affairs power in the environmental law area, and the Teo decision of the Anthony Mason Court, in which he talked about a legitimate expectation that our government officials will have read the Convention on the Rights of the Child. In the M60 case I mentioned to you before, the Bangladeshi case, not a single judge, not even the dissenting judge, but not a single judge mentioned any international treaties to which Australia is party. In other words, the international jurisprudence and the international obligations are invariably ignored. Well, that's a grim tale. I've got a better tale to finish with, and that is, I was reading a judgment the other day of a federal court judge, all on his own, and there are many cases of this kind, but it was a young boy aged about 10 who's been suicidal on Nauru. You would be after 5 years of living there. It's a dangerous place, and most of the children have at least medium levels of psychological and mental difficulties. I think we all know that it's empirically, objectively true. The medical profession working in, typically Australian doctors, working in Nauru, had been pleading with the Migration Department our new super ministry, to allow this child to be brought to Australia with his mother for proper medical care. And he had attempted suicide on a number of occasions. The minister had declared that to, as we've heard him say, one scintilla of compassion will bring the entire system of stopping the boats and stopping people smugglers falling apart. We cannot afford compassion. Well, the lawyers brought this particular matter to the courts, to the federal court, and this particular federal judge looked at the medical evidence, the objective evidence, said this child was in deep distress, that there was an obligation, not under any of the principles I've been talking about tonight, but the simple principle of negligence and duty of care under Australian negligence law. Australia owes a duty of care to these children and their families. And he said he ordered the minister and the department to bring the mother and the child to Australia for proper medical treatment until he was in a fit state, hopefully never to be returned, but possibly. But what was really interesting was that this judge checked the flight schedule of planes leaving Nauru for Australia. And he finished his judgment, and I've never seen this before. He said, I expect to see the mother and child on that plane tomorrow morning. And indeed, that's what's happened. So there are some growing numbers of cases where judges have been able to find another principle, not the ones that I care so much about in my job, but simple principles of the common law, the duty of care, of negligence. Every second-year law student will know those principles of the duty of care. So you can get there, the courts can get there, but my view is that a Charter of Rights, a simple charter that's a dialogue model, leaves the decision up to Parliament in the end, but which sets a benchmark that gives the courts the tools to respond to these cases, to say to Parliament, you may not pass retrospective laws that are penal. You may not exclude the provisions of the Refugee Convention and say that the return of somebody to a country of discrimination and persecution is not a reason for refusing to deport him. To make sure that these principles are part of the Australia that I think we were and certainly aspired to be up until that turning point in our history. So above all, I think the Charter would bring Australia back into protection of the rule of law and to the principles of legality on which I believe our successful multicultural society depends. Thank you very much.